Welcome to Video Vocab by BusinessEnglishPod.com.
Video Vocab 06, Commercial Law. Hello, and welcome back to Business English Pod for the final part in our three-part series on the law and legal vocabulary. Today, we're going to be covering some of the common legal terms used in commercial law. Before we get started, let's check what you've remembered from the last show on court cases. See how you do with these questions. Ready? Okay, let's start with a couple of easy ones. Question 1. What's the name for a lawyer in British English? 2. What do we call a person who is testifying in a court case? All right, a little harder now. 3. When the jury retires, what verb do we use to describe their discussion of the case? And finally, 4. How do we spell jail in British English? Okay, how did you do? The answer to number 1 is solicitor. The answer to number 2, a person who provides testimony in a court case, is called a witness. Question number 3. When the jury retires, we say that they will deliberate the case. And lastly, 4. How do our British friends spell jail? G-A-O-L. But remember, it's pronounced the same as the American word jail, J-A-I-L, regardless of the spelling difference. All right, let's move on to today's topic, commercial law. We're going to begin by looking at the types of disputes that are covered under commercial law. A dispute is a disagreement between two parties. In commercial law, these parties are often two companies, or a company and one of its employees. The word party in legal language is used to refer to a person or people on one side of an argument or dispute. Parties to the dispute is a collocation we use to refer to all sides in a legal argument or court case. Contractual disputes are a common reason for disagreements between companies. These are disputes based on a disagreement over the terms of a contract. A contract refers to any agreement, written or spoken, that is enforceable by law, and the terms of a contract are all the conditions that each side must fulfill in order to validate the contract. We can make a contract, break a contract, and be under contract. We can also use contract as a verb, as in contract with another party, meaning to enter into a legal agreement. Or we can contract work out, meaning to arrange for work to be done by another company. For example, to cut costs, many companies have contracted out business operations to offshore companies. Contract law is the area of commercial law used to regulate contracts between individuals and companies. To regulate just means to control or supervise something by means of rules or regulations. Another area that we hear quite a lot about these days, especially with the popularity of YouTube and other online video and music sharing services, is copyright law and intellectual property rights, usually abbreviated to IPR. Intellectual property is an original creative work or invention, such as a movie script or computer software. And rights are the ownership or permission to use a particular work. We use the word piracy to describe the unauthorized use or reproduction of another's work. Copyright is the exclusive legal right given to the creator or owner of a work to use the work to their benefit. Exclusive rights means that only the owner has the right to use, perform, or otherwise benefit from the work. We also have many other types of rights, such as property rights. These are the rights of property owners and people who buy or lease property. Human rights. These are the basic rights that society considers belong to every human being. Civil rights. These are the rights of citizens to political and social freedom and equality. Another area of law that comes under the umbrella of commercial law is labor law, sometimes referred to as employment law. If you have a job, then you will most likely have an employment contract with your employer. This basically states that you will work a certain number of hours, and in return, your employer will pay you a salary and other benefits. If a dispute arises between an employer and employee, the case will usually be heard under labor law rather than contract law. Legal disputes often arise when one party to a contract accuses the other party of violating the terms of the contract. To violate means to break the agreement or not fulfill one of the terms. Okay, those are some reasons why legal disputes happen. Now, let's take a look at the vocabulary we use to describe the different actions in a commercial case. The first stage in a contractual dispute is often to enter into arbitration. Arbitration is the term we use to describe the process by which the parties to a dispute submit their differences to the judgment of an impartial person appointed with the agreement of both sides, or by a regulating authority, such as a professional organization. To be impartial means that you will treat both sides fairly and equally. Note two strong collocations here: enter into arbitration and go to arbitration, meaning to begin the process of arbitrating a dispute. Arbitration can be either binding or non-binding. If it is binding arbitration, then the decision of the arbitrator must be followed. Non-binding arbitration means the decision cannot be enforced by law, but is based on professional respect for the arbitrator's decision. The arbitrator is usually an experienced and respected member of the relevant industry, or a lawyer. The accusing company can also file a lawsuit to have the dispute heard in a formal court hearing. A lawsuit is a claim or complaint against a person or an organization that is made in a court of law by a private person or company. To file a lawsuit is a collocation used to describe the action of suing another party in court. These are a couple of important words, so let's take a closer look at them. Lawsuit can partner with these words to make strong collocations. We can bring a lawsuit against somebody, defend against a lawsuit, or drop a lawsuit. This means that the plaintiff has decided not to pursue the case. To sue means to make a legal claim against someone, especially for an amount of money, because you have been harmed in some way. Sue partners with two prepositions, to sue for and to sue over. Here are a couple of example sentences. The company was sued for damages by the injured worker. YouTube has been sued over its use of copyrighted material. A more formal word with the same meaning as to sue is to litigate. And the process of suing another party can be referred to as litigation. If we decide to sue somebody, then we can say we have entered into litigation. The company that files a lawsuit is called the plaintiff in civil law, and the company defending against the lawsuit is called the defendant. The plaintiff will often seek damages from the defending party as compensation for any harm caused by the defendant. Damages are money that a court orders someone to pay the plaintiff for harming them or their property or causing them financial loss. Due to the high cost of legal action and the complexity of many commercial cases, both parties will often attempt to reach a settlement in order to avoid a lengthy, expensive court case. A settlement is an agreement to resolve a dispute before it is taken to court. We use the collocation to settle out of court to describe this action. If the parties do not settle the case out of court, then a court hearing, organized in a similar fashion to criminal cases, will be held. There, each side can state their case, ask witnesses to provide testimony, present evidence, and litigate their claims. After the plaintiff and defendant have presented their cases, a jury or judge will decide the verdict. They can choose to dismiss the case if they do not find that the plaintiff has proven their case, or they can award damages if they think the plaintiff is right. A judge may also issue an injunction against the defendant. An injunction is a judicial order demanding that the offending party stop infringing the other party's legal rights. Should the defendant disagree with the verdict, they might choose to file an appeal to have the verdict overturned, or to reduce the amount of damages they are liable for. An appeal is a formal court process by which the losing side asks a higher court to overturn or reverse the verdict of the lower court. Well, that about wraps up our series on legal vocabulary. We hope you found the podcast informative and useful in your jobs and studies. To help illustrate how many of these terms can be used, our next business news podcast will look at some commercial disputes that have been making the news recently. So we'll see you soon, and don't forget,